You are now live.
Very good. Is there a motion to convene the meeting of the ad hoc ethics code review committee?
I make a motion.
Is there a second?
I second.
All in favor, say aye or signify.
Aye.
Any opposed? Okay, we are convened. You may have, hope you saw that I made some editorial changes to the minutes only insofar as the notice at the header of the minutes that shortening the information regarding the public, the fact that the meetings are available on Zoom and YouTube, and trust that I hope met with everyone's approval. With that in mind, is there a motion to review, to approve the revised minutes of December 9th and December 11th, 2020?
I make a motion to approve both.
Second?
Second.
Any discussion on the motion? Very good. All in favor, please say aye or signify by raising hands.
Aye.
Motion is carried, and thank you for that. And again, thank you, Brian, for bearing with my editorial changes. Someone said that I could create a typographical error by looking at something. And I spent years reviewing reports which went out to clients, so I get a little finicky about it, and you've been a very brave soldier, Brian, in putting up with that, so thank you.
Oh, thank you.
Is there a motion to approve the minutes of our meeting on December 18?
I make a motion to approve the December 18th minutes.
Is there a second?
A second.
Any discussion on those minutes as edited?
No, but I'm sorry they were so late, and they'll be earlier.
You
Oh,
don't-
Brian, don't be silly.
You are the fastest secretarial gun in Mamaroneck,
I tried.
at least.
Thank you.
Any discussion on that motion? If not, all in favor, aye or raise hands.
Aye.
Aye.
Motion is carried. The minutes are approved, and Brian, you can put those in final.
All right. Thank you.
Okay. Item number 3. And by the way, we're going to try to go, with your indulgence, at least 75 minutes today. And if you have to jump off, I understand that. Our fate for January will be presumably decided at the next meeting of the Mamaroneck Board of Trustees, and before in December, I believe on the 28th. So hopefully everything I'm going to be saying about meeting in January will come to fruition. Item number 3 on the agenda, the status of emailing the ad hoc committee's letter to community organizations and others. Brian, I trust you've emailed those organizations that had emails on that list?
Yeah, I did. And I think I did it on Sunday, I want to say, of this week. And I think 5 came back as non-sendable for some reason. I guess like some websites were out of function.
Right. That I think is not surprising, and that list may have been very old and probably not updated. And with respect to the mailing, the actual snail mailing of those letters, I think we have some indication that the village hasn't gotten to it, won't get to it, at least this month.
All right. And then I had a question, sorry, if
Yes,
like there's a new organization that I come across, do you just want me to email the same email?
absolutely.
All right.
Absolutely. This is more is better.
Okay. Because like I don't want to miss anyone. I don't want anyone to be left out.
Right.
I just, One thing on that, and Brian, I saw that you were using your personal email for the outbound mailing of this. Is there any way that we can have the village email utilized here? I just think as a committee that this should be coming from an official address, an outbound communication. I know it complicates things. I just think professionally, it's best if it's the village email address.
You're right, Mike. And I did ask Brian or told Brian that if he had any reservation, it needn't be that way. And he uh, quite valiantly offered to use his email address.
Well, that's fine with
And
me.
my view was that the idea was to get it out because the village has not been supportive in that regard. And again, I'll say for the record that I'm not blaming any village employee. Their explanation has been that they have a lot of work, and I have no doubt that they do. Perhaps what we might be able to do is use the dedicated email box that we have for that purpose and take control of it. for
I agree.
Of sending out an email. That email account is live. It's actually featured on the village website now, as is our committee. So what
If that doesn't work, I don't mean to interject, but perhaps if that doesn't work, a generic Gmail account could be set up that would be something to the effect of Mamaroneck ad hoc, ethics committee @gmail.com. So that way Brian isn't dealing with everybody in the world having his personal email.
They can, I don't mind.
It's a good suggestion. My concern about that is that when I get something, an email from a Gmail account that I don't recognize, I don't open it. So
Fair
it's
enough.
possible that might vanish into cyberspace.
True.
I will ask Sally unless she's listening, if we can get control of that and send out on our own and not rely upon a village employee, use that email box to send out communications.
Dan, I'll check with Cliff and I'll let you know because I don't.
Thank you. Thank you so much for that. Okay. Number 4, still on 4, the status of mailing our letter to Village of Mamaroneck employees. When we met a week ago, last Friday, we talked about writing a letter at some point to the Board of Trustees expressing our concern about communicating the letter to village employees. And I have, and expressing our strong opinion about the failure to do so. I have drafted such a letter. Because it's a strong letter, and I'm not going to make it a record of I'm not going to put it on the public record now because everything we're doing here is public record, because I don't want to be provocative in any way right now. However, if by our next meeting there is no such letter, the letter does not go out to employees, village employees, then I'm going to, I think the appropriate thing to do would be to alert the Watermore trustees, at least verbally, that we're about to go on record with a strong letter. And once that letter is communicated, it's immortalized. And see
Dan, no, I'm sorry. I thought you were finished. Nora will be at our January meeting because she'll be running the Zoom portion.
yeah.
So that might be the time to raise it to Nora,
Perfect,
which then gets it in our minutes as well.
perfect. So I want to give them, I want to be patient, but at some point, we have to make the record. So that's a very good idea. Thank you for that. And if after a reasonable period of time, and I'm not talking about a long period of time, there is still no action, then I think I will circulate the letters so you guys can say whether it's appropriate or amend it, edit it as you see fit. Okay. Number 5, status of the committee's request for extension of the date to complete the work. I believe that the board is meeting on December 28th. I believe that the extension is near, or if not near, top of the list. And hopefully we get extended. If not, it's been really great meeting you all.
The agenda for the meeting on the 28th just came out. Yes, that is on the agenda.
Great. Okay. So I'm optimistic and look forward to our continued work together.
So it's not over yet.
Okay. Okay. Before I get to number 6, the review of the Code of Ethics, John, thank you for your email of yesterday with those enclosures. And you will have seen
Sure.
my communication just to the Attorney General website, and then a direct communication to the fellow from the New York Conference of Mayors, and that was a wonderful suggestion from Nora, because his reply answered a couple of questions. Is there a compelling reason for us to discuss that now, or can we take that up at our next meeting?
No, I don't think there's anything compelling or driving it for right now, but I just think it's some issue. There are some issues raised that maybe we should discuss. But I do think, and I think on many levels, the website that I shot to the committee that gives an outline of the cases. You know, these are not just opinions regarding open meetings law. There are cases that have gone to full adjudication. So I would think, I would venture a guess that not every board is aware of those cases. And I would think, as part of any ethics, maybe education, that they should be, you know, that summary page should be, you know, shared among committee and board members so that they're aware to read through. Because it provides a good brief education in some of the issues that they may face.
Great. Thank you for that.
So John, let me ask you a question on that. Are you proposing that we include a one-pager on open meetings in the doc, maybe as an appendix, an FYI?
I would think that would be a good thing to include for any. I think that should be, I think, separate from the Board of Ethics itself. It may be a good idea for sort of any at the annual meeting for every member to get sort of an FYI about the open meetings law. Every member of every committee, because
Yep.
I think there's a lot of confusion about it. There seems to be the presumption that on many of the committees that, well, there are several presumptions from my experience working, you know, being on the Board of Trustees and working with committees, that first of all, if if they don't have any decision-making ability, I think this is a discussion that we can probably have at another time. But generally, I think there's a lot of confusion about open meetings law for many of the committees.
John, I don't disagree with you, and I hear what you're saying. Is that directly related to our mission here? And is that worthy to say we want to highlight this? And I don't know if a violation of the open meetings law, I'm not saying it's correct. I just don't know, is that really an ethical issue that needs to be addressed in our review of the processes of the board?
I think if you look at it sort of backwards the other way, the ethics board, from what I understood when we met with them, was under the presumption that many of their meetings were not subject to the open meetings law. And if you read through many of the cases, it spells out pretty plainly that they are the subject to the open meetings law. And I think in that scheme, I think, we're looking at it from a specific, ethics board issue. And I think there's an issue regarding the open meetings law with the ethics board. And I think on a larger scale, there are issues with other boards.
So
I
then
don't think it's necessarily an ethics violation. You know what I mean?
Yeah, I'm more comfortable. I agree. And after you say that, John, I'm with you. I just would like to keep this contained to the processes of the ethics board without putting this out as guidance to the other boards. I feel like that is something that's probably more the village trustees' responsibility to do. And I think that if our mission was to review the processes and the rules and regulations of the ethics board, I think we add that in there, that it's important that they understand the open meetings law as part of their processes, but don't go any further and tell the other boards what they should do.
right,
Fair
so I
enough.
think
Yeah,
maybe it should be in this section under what the ethics board is responsible for. Comply with open meetings law, a one-liner.
fair enough. I mean, but I think from what I heard when we met with the ethics board, there seemed to be the presumption that if things exist outside of a village server, they're not village documents.
I disagree with that 100%. And I'd be honest with you, as we exchange these emails back and forth amongst ourselves, I have kind of laid back a little bit, but I believe that this is all subject to open meetings.
So do I. I agree, but I
Yep.
think the ethics board has been sort of led to believe that is not the case. And I'm, and part of the one case that I noted when I sent my email was essentially that a violation of the open meetings law essentially invalidated a board's actions. And that would be a shame for the ethics board to be in a situation like that if they did not get the correct advice. That's all.
All right, I would like to move on to the sections, but reserve this discussion for a portion of our next meeting. In the interim, let's all do the reading we need to do, and following up on what John sent us, I will certainly undertake some review of this, and I think we can fairly resolve to come to to address the issue, if not necessarily all agree on it, but to address the issue before we conclude our business, so that we have provided attention to this and acknowledge that we have reviewed it.
Sure.
It may wind up with our sending this off to the village council or to recommend to the board that they obtain some legal opinion regarding this. We are, after all, reviewing the code. We are not making judicial decisions here.
Right.
So if I may, I'm going to the notes, the annotated code section notes that I sent to you and working my way through. I doubt that we'll get through, I mean, we won't get through all of it, but let's see what we can do and shorten our list as we proceed. So I started with the definitions section, and just jump in if I've misstated anything or you need to make a comment. As per our discussion, I deleted the categories which were superfluous or unnecessary and bunched for here, immediate family member, sibling, household member, all under the term relative, which is in front of you. And I defined household member in effect in that highlighted blue section, or made reference to what I think we all were aiming at. Under officer, board member, and employee, I did include consultant. And let me get down there. Or up there.
Up there, you just scroll too much.
We're going up or down?
Go
Down.
down. Wait, no,
There we go.
right there. Yep.
All right. So this is not necessarily a discussion for now, but there may be a value in choosing one word as applicable for officer, board member, or employee. I plugged in consultant, and I believe that this may lighten our task in the sense that we start with the presumption that everybody's covered, but there may be a section or more than one section where we do not intend to mean one of the
So
four.
can I make a suggestion?
Yeah.
Last week you recommended an acronym, and I
Yeah.
think using an acronym is safer than a.
Ellen, you froze.
Ellen froze.
Ugh,
There you go.
okay.
Last part we heard you say was safer.
Than using a real word. So employee has a meaning of its own.
Correct.
So if we use an acronym, someone's going to have to stop and think, what does that acronym mean?
Right.
So I prefer the acronym. That's just my opinion.
All right. Well, Vobek just flows from.
Or it could be VOBE. I'll drop off the two C's. That's fine. But I think an acronym makes it clear throughout the document that it refers to a previous definition.
Does anybody have a recollection or knowledge of what other codes do in this definition section?
I don't think, from what I recall, but I'm not 100% sure, I don't think the other municipalities had as broad a definition. And I think they kept spelling it out, but their code in total was much shorter.
Okay.
So it wasn't an issue to keep repeating it.
Any other views on whether we use an acronym or some other term? Right.
My concern with an acronym is people will look at just one section of the code. They will not look for the definition.
And my concern with using the word employee is someone's going to say, I'm not an employee, I'm a committee member. Doesn't apply to me.
I guess the alternative is just to spell the whole thing out.
Ugh.
But all right, let's think about that. I will tell you that apropos of what Mike said earlier, it took a lot of restraint on my part in referring to the who, not to say that if we use the right term, we won't get fooled again.
Right.
That's a Who song. Or we're not going to take it. So
We could just use the term Tommy.
so there I've already immortalized my sarcasm, but at least it's not in print. Brian, stop writing.
We're recorded.
I want to put one thing there because I think it's important. I hear what you're saying, John, about if they just open up one section, but we've talked about the requirement to have this posted in village workplaces and that it's going to be emailed and everybody's mandated to read it. So I think they've got a responsibility. It's very clear to be aware of what's going on with this. You know what I mean? And
Yeah.
they should read this and they should look at it and they should know about it, right? And if they didn't, that's on them.
And we are going to require that they read it and say they understand it.
Yep.
And we've talked about that. I feel like, you know what? If they open up one section, that's on them.
Okay, moving on to definition section of customer or client. 21, it really goes down to 21-4 B1A. Am I right about that? Is that where I am?
Yep.
Yeah. Now, I tried to lay out this. I don't think any of us understood why the qualification in this section was inserted. And I gave you in the notes a hypothetical in which a consultant who does not have a professional license could violate the letter and spirit of this section, but not be penalized because that person does not have a professional license. So where I come out is I favor deleting this phrase. Subject to another source telling us, no, there is a specific reason for why it's in there.
I think that's a good idea. I think we should remove it. I mean, if somebody came back, Dan, and said, no, it's got to be in there for that reason, I would almost think that what you're saying, we just put that in as the next paragraph and just remove the sentence professional license. I understand what you're saying, and I think you're 100% right there.
Okay, so I'm gonna strike it, and I think what I could also possibly do is we could ask the village attorney and the outgoing board members, well, the board, whether anybody knows why it's there. But for now, I'm taking it out. Okay, on to section 21-4 K2. Am I there? Sorry if I'm making you dizzy doing this. Am I in the right section? Sorry. 21-4 K2, special advantages. I think we've discussed this and agreed that we can't figure out what they meant by it. So there it is. So where the special advantages, I just advocate making it a blanket prohibition because special advantages does not appear anywhere. in any other law that I've seen. It's not model code. And it would be, if it's not defined in the code, then it's void for vagueness. Any issue with that?
Nope.
Not, I'm going to go on to 21(7)D. ABC, there we go. Okay. Okay. First, regarding change of political party, what I provided there is that in the event a member changes their party registration and thereby creates an impermissible imbalance in political party registration, that they have in effect vacated their office. If they realize it was a mistake of some kind, they didn't realize they were doing the wrong thing, it's curable within 10 days. They can void that re-registration and stay on the board.
Can you do it in that time frame though? Is that realistic that you can void your change in a 10-day period? I just don't know.
I suppose you could send a letter to the appropriate authority and
Or
indicate.
change it, or you just change it back to what it was, and they provide some sort of proof.
That's just an instant thing is what I was asking. I just don't know the time. I just don't want to put a time frame that's not doable.
I
Like,
think that the time frame, because it's not going to happen in 10 days, I agree. I just think that the person has to renounce that change within the time frame and maybe serve that letter to the board or whatever, to whoever we want, but just so long as he renounces it within the 10 days, right? It will allow for the administrative paperwork to catch up. We know what his or her intention is, and it would allow that to work through.
Should
that makes,
we give them more time? Should it be 30 days?
well, or change it that they've demonstrated that they are like they've initiated the process to do so. I think addresses,
Yeah.
as Mike says. I think that's like it could take much longer. And this way, they've provided proof that they are in flight. So I think that would be easier than trying to figure out how long an administrative process you have no control over will take.
So are we saying you have 10 days from the day you start the process, correct?
Yeah, I was
Well,
wondering about that too, because I think there's like weird timelines. Like if you do it, I don't know, New York has weird timelines regarding party like changing of the party. So I think it has to go into effect like after election day or something. Like there's very weird timelines. So are we saying like within 10 days of the change, or if it takes effect? Because if you change it in like October and then it doesn't take effect until November,
Right.
like two people are still on the same party and it didn't get through yet.
So that's my concern, is just because hypothetically somebody is changing parties. I think this is a rarity and probably unlikely to happen, but you never know. But somebody changes notifies the state that they want to change, or the county county board of elections that they want to change parties. But are we saying 10 days from the notification or 10 days from when it's registered? Because a resident who changes their party, other than sending in a request to change party, there's really no way of anybody knowing. We would never, there's no record of a party change until like Brian said, in November. Or the
How
first
about is revoked
primary.
within 10 days of when such changes to take effect?
Yeah, but I think if
No.
someone wants to change their party, the intent is there. So
Right.
if that intent alone creates the imbalance, whether it's taken effect or not. I think they need to come forward.
I agree. I think when the person submits the change, they have 10 days at that point to renounce that change and be online. And we may not know, but a lot of this, nobody ever knows. I think at the end, there should be, I don't want to say a discipline associated, but like anything here, there's a potential sanction, right? And so
Or-
if they fail to do this, what would the potential sanction be at the end of the
or potentially would invalidate decisions that they made in that period.
you know what, John? I don't know if it would invalidate, because then that really disrupts the
No, I
other
know, but I mean,
legitimate right to decide on stuff. I think that's maybe something that council should weigh in on.
Sorry.
You- I would say that, so let's say the problem here is that we're saying that the individual does it with an understanding that they shouldn't be doing it. I think it should be, they have 10 days to cure from the time it's identified that this was something they can't do in their current seat, or they need to resign their seat. Someone can switch their party and not know that that is in violation of their seat on the board. So that's what I think. It should be 10 days to cure from that point of, I don't know how we find out or how we know, but I just think that you can't hold someone accountable for something they didn't know, or you have to point out it's in violation.
I think that they should be fully aware of the rules and regulations for this board that they're going to sit on, and they should know what it is. I mean, ignorance of the law isn't a defense, and I think in this case, if they're going to sit on this committee, they should fully know everything that's expected of them.
Yeah, I agree, but I had a question where it says the result of which is that more than 2 members of the board are registered. Should it say are or will be registered in the same political party? Because like we said, it doesn't take effect until after November. Like say if like 2 people on the board of ethics are like, oh, let's change parties, like I'll change it. So like no more than 2 people are on the same party. Then does the latter person get disciplined? Does the second person get disciplined?
Person who, the only impact on this is of the person who changes their registration.
But if 2 people, I'm saying, change, and then they just switch political party, so like there's still a balance, but does the second person who changed? My point is,
I
like,
think it's got to be
doesn't
limited
affect
to the
until
individual,
after election
and that
day.
You can't, I think we need to make it clear, you can't change your affiliation if you are sitting on the board. I think that's what you're saying violation of, right, Mike? So if you change, it will possibly create an imbalance, or maybe not, but that's not the point, right?
No,
Yeah,
I think
I-
the point is that it creates an imbalance. Like if I wanted to, I want to leave and be an independent, that's fine, because an independent is not a political party. There's the Independence Party, but if I'm not affiliated, that's no problem.
Correct.
My concern is we're saying if a person chooses to change parties, which I have no problem with that. My feeling is they have to notify the village within 10 days of filing for the change. And my concern is if you don't notify the village within 5 days of the change, and we're saying that balance on this board matters, what do we do? Because essentially what we're saying is, theoretically, somebody could be in a situation where they've had an unfair situation, an imbalanced board hearing an ethics issue.
John, how about this? How about, a member of the board who chooses to change their affiliation must immediately notify whoever immediately, right?
Yeah, no,
And that
I'm
they-
fine, I'm
and that
fine
if
with
they-
that.
If they don't within whatever period of time we choose, their seat is vacated. And so, at the point that they immediately notify somebody, it puts people on notice, okay, we have an imbalance. It would allow the board to hold judgment on something or not commence an action. And then within 10 days, this person has the chance to,
I'm fine with 10 days and, from the date they start the process. I'm fine with that. I just think, first of all, I think they should have to notify the other members of the ethics board, and they should also have to notify the board of trustees. Because their change puts the rest of the ethics board in a, compromises their ability to do their work.
Yeah, I think I like that upon changing registration, they are compelled to notify the two boards.
I wouldn't say on changing registration, because I think we're having an issue here about when technically registration changes. I think once they have filed for changing their party, they have 10 days to notify.
And and what is the consequence of the imbalance that they've created?
Right, that's the problem.
Well, if they're
That
first,
doesn't get addressed.
right, if they're first to do it, they're fine and they're treated one way, right? We have no issue if they change. It's only if you're the person creating the imbalance, you're the second person or third. And I do think there's a high unlikelihood that one by one, but if you are the person creating the imbalance, I think that's where it becomes an issue. Do we agree?
Yes.
Yeah, my concern is one raised by either I think either John or Mike, that if by active re-registration the they have violated the provision that no more than 2 members of the board shall be registered in the same party, that calls into question whether any action taken by the board is a legal one. And so probably what they need to do is they need to notify the Board of Ethics and the Board of Trustees upon their re-registration, but that if that re-registration creates an imbalance, I think it has to be a vacator of office right there.
I agree with you on that. And I
But-
have in the Racy matrix,
You froze again.
Yeah, Dan, I agree with you. It's an immediate vacating of the office, right? And then if we want to allow for a provision or a suspension of the office where the subject could renounce within 10 days or whatever time period, right? They could continue. But I think we're all in agreement here. This is a problem. It's just the timelines. And I feel it's got to be an immediate notification. So it'll allow other people to take action.
Yeah, I agree. I just am concerned that that they have in effect delegitimized the board. All right,
well, that's why they need to notify immediately. They're removed from the board. And
Right.
it's up to the Board of Trustees to replace the person. But I've just made a note in the Racy matrix. I don't know if you all agree with this, to include an annual review of party affiliation by the Board of Trustees.
Yeah.
To be proactive instead of reactive.
Good idea.
I mean, I agree with Mike that it's got to be an immediate notification, and if it doesn't sway the board, like one way or the other out of balance according to the code, then I guess the seat gets retained. But if it puts the balance of the board out of code, then I guess they would vacate their seat. I mean, one way to solve this whole problem is just to say, if you're on the ethics board, you can't change political affiliation. And if you choose to if you choose to change, you automatically invalidate your seat. I don't know. I don't know what the solution is. And I don't think people should be prevented from changing parties, but I just,
Yeah, I don't know that that would stand up.
I mean, I'm not making this suggestion, but another solution is just take out no more than 2 members of the ethics board should be registered in the same political party and just have a free for all. But I'm not suggesting that. That's another potential solution.
No, I think there's a value in
No, I agree.
And
preserving.
it's also in the model code, and all the other municipalities have this, so we're not alone in this.
Good. Okay, let's move on then, and I'll play with this, not play with this, I'll rework this so that I'll
I
read.
would imagine the likelihood is pretty slim on
Yep.
most of it anyway.
I agree.
Yeah, I'll redraft this and send it out on the next next set of notes with the next agenda. So now on 21.7B, and no, 21.7D, the top of this paragraph, which says no ethics board member shall be employed or act as a lobbyist before the Village of Mamaroneck, the Town of Rye, or the Town of Mamaroneck. Now, the code does not define lobbyist. And so the question number 1 is, do we define lobbyist? And question number 2 is, should the prohibition be broader than this geographic area? And the term lobbying, there is a definition in the New York City Charter and the New York State Legislative Act. They are very, very long. If we included the full definition, it would probably constitute it would be the longest definition in the code. And so my question is, which is this too much? I mean, if you're going to prohibit lobbying, you must define it.
I agree, but just, one thing should we broaden the area? I mean, even if we keep it at the Village of Mamaroneck, Town of Rye, Town of Mamaroneck, should we at least add the County of Westchester and the State of New York in there? Right? Just so all layers of government that would, have an impact on the village are covered.
All right,
I
taking
think
up
that's
that,
too broad.
you do?
Yeah, I agree.
The state of New York, yeah, that's too broad.
I think so.
What about Westchester and contiguous counties?
I think that's too broad too.
So do I.
Like, imagine we had one like, oh, you can't be a lobbyist in Congress. Like, I don't know,
Well,
I just think it's
what
too
I was
broad.
thinking of is,
I think what we have now is okay.
what about the County of Westchester?
I think that's too broad. That's a gray area. Connecticut doesn't even have county government. That's not fair.
Well, we are governed by counties.
Yeah.
And villages.
I just maybe, what would the reason be for not having them work with the Town of Rye and the Town of Mamaroneck? As opposed to the Town of Harrison, right, which is a bordering area. And so my feeling is, I know we asked whoever what's up, is because those are the 2 towns that the village overlays, right? And so when I look at the overlay, I'm saying, well, it's also overlaying the county and it's a state, and maybe the wording there, if we took the state out, fine, but the county, and I think the fact that Town of Rye and the Town of Mamaroneck is because that's what the village is. It's not mentioning the Town of Harrison, which is, as close to my house as, anywhere in the Town of Mamaroneck.
Right, but I mean, that part of that sentence says you can't be employed by. So, Mike, what that means is you couldn't be on the ethics board because you work for New York State. Do you think that's right?
No, no, I'm just saying this. I'm just highlighting the fact here that we've identified the town of Rye and the town of Mamaroneck. For what reasons? What would the town of Rye versus the town of Harrison?
I
Because I
think
think there,
Harrison should be included, but
well, I
Okay,
think the
that's
town
what
of
I'm looking at. I'm
Rye,
thinking it's too small.
I think the town of Rye and the town of Mamaroneck are in there because the village consists of portions of the town of Rye and the town of Mamaroneck.
Yeah.
I
That's-
agree, but it also consists of the county, right? And something could happen on the town side of Mamaroneck, has no bearing on the town of Rye. It just looks to me, John, like this overlay was for a reason. Mamaroneck and Rye is the towns because that's the village is overlaying that. I mean, the county is part of that also.
I can
I'm good either way.
I can understand not prohibiting a board member from being, say, employed by by a neighboring town or village or the county for that matter. But I don't understand, I don't see why someone sitting on the Board of Ethics would be lobbying for anything, given their responsibility as a member of the Board of Ethics. We're certainly not lobbying anywhere near the village of Mamaroneck.
but I think that gets to how we define lobbyist.
Absolutely.
Yep.
Yeah, because act as a lobbyist, that's like very broad, I feel like, or could be interpreted very broadly.
It's very hard to narrow the definition of lobbyist because I read the statute. I read the state and the city, New York City Charter. And it's very hard to narrow that down beyond, well, in my first try at least, as to where I have it in my notes. Because when you're a lobbyist, you're representing somebody and trying to get something done before a public office, a public official, a senate, an assembly, a board of trustees, a zoning board. There are just so many entities that a lobbyist can be active before. So I think.
Dan?
Yes, go ahead.
No, I just maybe, I think Ellen mentioned here, being employed and maybe where we look at this, I don't know if a lobbyist should be on the ethics board. Maybe we just separate this into different sections, right? So we can determine, whether a member of the ethics board could be a lobbyist and then what the parameters would be for employment.
Right, but then we have to be very clear on the definition of lobbyist.
I mean, just my experience is I think this was an effort to make sure that an ethics board member who may have clients or may be a member of an organization, a not-for-profit organization that could theoretically appear before the village of Mamaroneck to ask for, let's just say somebody was a member of the Lions Club and they were on the ethics board and they had to appear before, the village on behalf of one of the land use boards. I think this was an effort to make sure that an ethics board member would not be appearing on, before a land use member, on behalf of a not-for-profit or an organization that they work with. I don't know for sure, but that's what it seems like after reading through this and having that discussion. And, I think there's some fairness to that. But I don't know that lobbyist is technically the right term.
Right, so in that case, John, lobbyist or lobby is really used as a verb. It's an action to appear before the board,
Right.
not a lobbyist as we know it from, a political action
Yeah,
committee.
not from Congress.
Right.
Well, maybe the way to get around that, but still attain the purpose of the section, is to omit the word lobbyist, but instead define the conduct that we believe would be unethical.
Sorry, and then after Town of Mamaroneck, could we just make it clear, like including any of its boards? Because I feel like before the Village of Mamaroneck, the Town of Rye, the Town of Mamaroneck, like I feel like someone would be like, oh, well, if I'm appearing before the Ad hoc Ethics Code Committee and I'm an ethics board member, which has happened, like we've had a joint meeting with them, is that prohibited? Because are they acting as a lobbyist?
No, because they weren't asking us to do anything. We were asking them.
Right.
Yeah, so we need to make it just clear, I guess, like what the parameters are.
I think if we define what we mean by prohibited activity rather than pushing the hot button of lobbyist, we may get to where we need to be.
But I think if you're gonna, and you're good at,
Oh, you froze again.
We
You're
think you're
back.
back, Ellen.
huh?
We think you're back. You froze.
I hate my internet. We need to include the employed by in your generic definition because we're basically saying we don't want anyone to volunteer to be on the ethics board who works for a neighboring municipality when they could be adding a lot of value. So it's the behaviors. I agree with you on the behavior end.
You know, maybe I've read this wrong. No ethics board member shall hold office in a political party. No ethics board member shall be employed or act as a lobbyist. I wonder if the intent was that the two verbs are confusing. And what was intended to be prohibited was not to prohibit an employee from being on the ethics board, but to be employed as a lobbyist. You get what I mean?
Yep.
In other words,
Yeah, and then later in the middle, it says no ethics board member shall hold elective office and blah, 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 or be an appointed officer or employee of the Village of Mamaroneck.
yeah, so-
Well, that goes to the other question that we, I don't know if you guys read through the piece that was sent by, was it John Mancini or Joe Mancini?
yeah, John Mancini.
Who basically noted that, in fact, we should be appointing a member of an elected, a member of the elected board to the ethics board.
Yep. But they did say, or you could pass a law.
No, I agree. But, ideally, the model law would be preferred, but you
Yep.
can choose to do whatever you want.
And most of the municipalities we looked at did have an appointed official or an elected official.
Right.
Okay,
So something else to consider because that would have to be adjusted.
Yep.
right. So why don't, again, as with the other section, I see if I can deconstruct this and come up with a couple of suggestions as to how we might approach this, and we'll take it up at the next meeting. So we're moving. We're doing great. We're doing great here. Let's go on, if I may, to section 21 13E, and this is the issue relating to the board investigating itself. And what I did there was the current section says that the Board of Ethics must transmit a copy of a complaint made against the board or a member to the village manager, and that's it. So what I've done here is I've added a section which says that a complaint shall be referred to and investigated by the Board of Trustees or a special committee of the Board of Trustees. And that the investigation and any hearing and the disposition shall be administered in accordance with the provisions of the Code of Ethics.
The only thing I would make a point of is the Ethics Board is currently appointed by the Board of Trustees.
Yeah.
And I think the subcommittee or committee or however they choose to proceed should also be by the Board of Trustees, not appointed by the mayor. It should be consistent with. It should be consistent with who makes the appointment to the Ethics Board, I think.
And Dan, unless I'm reading it wrong, I don't think that there should be a choice here. I think it should be defined exactly what the process is. So it just takes the decision out, and it's a process. The process is followed, and nobody can say, well, they chose this version for this person or another version for somebody else.
I'm sorry, what specifically are you referring to?
May appoint a special committee.
Oh, so you're saying
Right.
knock out the special committee.
The way I'm reading it, it shall be investigated by a committee comprised of members of the Board of Trustees appointed to the mayor. The Board of Trustees may appoint the special committee. And I'm just not getting it. Is that the Board of Trustees, or is it not the Board of Trustees and possibly picked by the mayor? Right? Are there two separate avenues here? Could this be investigated by the Board of Trustees, or could in turn the mayor say, no, I'm not using the Board of Trustees for this one. I am using a committee.
No, yeah, that should be addressed. My intent here was not to tie up the Board of Trustees on what could be a very complicated case and take them away from the work that they're supposed to do day to day, so that they could appoint a special committee. The special committee comes back and says, this is what we found.
Could I offer one thing on this? And just, I kind of like structure and very defined operation terms. Could this committee be pre-identified ahead of time by virtue of their previous positions? And, I'm just saying, could they have been the chairperson of the ethics board the last time if they're not on the committee, or, certain village board members or positions? I don't know. I just think when we get to somebody picking people, why was a person picked versus another person, right?
What about the village justice?
Okay, but wait, but let's go back before the special committee. We've got, shall be investigated by a committee comprised of members of the Board of Trustees appointed by the mayor. What's that, appointed by the mayor?
My idea there was to have the mayor create a committee of the board for the purpose of conducting the investigation. That the whole board is not tied up on the investigation.
Well, I mean, you could almost say a committee comprised of three members of the Board of Trustees. I think you get into an open meetings issue here, because three members of the Board of Trustees represents a quorum, so you can't do that. So
But
you would have to.
And going back to saying, if we pre-identified people, right? Could the most recent Board of Ethics chairperson who's not on there, could that be one person? Could the police chief be another person? could the village attorney be the third person? And they're pre-established that this is that second level, right? And then unless one of them recuses himself, that's it. And maybe we add a third and fourth, so if there is a recusal there, right? And so that's the crew, and they sit on that committee as long as they meet those requirements.
Yeah, I think you're there with a former chair. You're kind of counting on that person to be available for a position that they may not be willing to accept. The police chief may have a contract that doesn't permit that. Their role in, I understand the,
I toss names out. I mean, I
Yeah.
just want to take the decision out of this
I'm
and have those
thinking,
people pre-established for periods.
I'm thinking the village justice.
I'm okay with justice.
Again, I'm not sure that would be. I think you just put it on the board of trustees, and I mean, if something is that serious that it gets to the level where the board of trustees has to be investigating, an issue with the board of ethics, I think it's a fairly serious issue, and they're the ones that are ultimately responsible. So that's my take. The goal is never to get it there.
Yeah, but it's what if,
No, I understand, but I mean, I agree. I don't know if, I think the problem with, first of all, the mayor only is, I think I don't know if you followed what happened. There was apparently an issue recently where there was a request, it went to the village manager, and then it never, I don't know that there was ever a clear adjudication of an issue, So I think it needs to be referred to the board of trustees, or it needs to be referred to, five people, the same size board as the Board of Ethics.
Look, if it was the board of trustees, I could live with that, right? If that's what it is. Again, I just feel very strongly about not allowing that to be picked, based on these things coming in.
Right.
So maybe the better way is to say the board of trustees as the elected officials, that they have to handle this.
Right. I'm going to go with that, unless anybody else has any other suggestion. I'm going to go with Board of Trustees and not qualify it further than that. Okay. Closing in on, I think what would be appropriate here, since I promised 75 minutes, would be to perhaps stop here. There are 2 more sections left for today's agenda. But when we met on the 18th, we discussed the January meetings and the fact that we need to be perhaps more sensitive to people for whom 12 p.m. on a Friday is not convenient for work. So why don't we, in the couple of minutes remaining, talk about a regular meeting date for 2021, and at a time that does not impinge on people's work schedules, or perhaps makes it at least more convenient than 12 p.m. on Fridays. So I throw that open now. Does 5 p.m. work for everyone? Should we
Yeah, we're
switch
just
it?
gonna mention that it's like really hard, like 5 p.m. Like a
Can you
lot of the
speak up, Ryan,
committees.
I didn't hear you.
Sorry, I said a lot of the committees meet at like 7 p.m. usually, even like when everyone was in person. Even now, committee members like the Board of Traffic Commissioners meets at like 7:30. other committees meet at like 7:30, so. if that's-
Budget committee meets at 7:30.
Yeah, so that's what I was wondering.
I am happy to meet. It's easy for me. I'm semi-retired. My schedule is my own. So I want to be respectful of people who have tighter schedules than I have, for sure.
But I'm flexible.
Is 7 PM, would people prefer to meet at 7 PM?
7 PM is fine for me.
Mike, Jocelyn?
I would go earlier if possible, but to be honest, I can do what the committee wants, right? I can make it work.
Wait, Mike, when you say earlier, what do you mean earlier?
5, 6 o'clock. But I'll be honest with you that, my work is really incident driven, and something happens, 5 o'clock, 2 o'clock, it just doesn't matter. So I can work with the board, whatever the committee wants to do.
Jocelyn, what's your situation?
Do we have a day in mind? It depends on the day.
Well, if it's the evening, it's not going to be Friday.
Okay. I have, hold on, I'm just looking at I cannot do, sorry. They
You should
changed,
stay away from Mondays if Nora is going to staff your meeting,
Correct.
Board of Trustee meeting nights.
Right. Sally, is she on other committees that we might have a conflict with?
She is, Ellen. She's liaison to a couple of other committees. So you may want to reach out to her or look at the village calendar.
Okay,
Other nights that she can't do it, but you may want to include her on this conversation.
All right, let me do that. And I'll ask Nora for a range of dates and times, days and times, and then come back to you all with, and then via email, we'll be able to coordinate our next date. Let me at least ask this. For the week of January, we're talking about the week of January 4th, is no, we're talking, yeah, we've agreed that this is our last meeting for the year. Anything in the week of January 4th, or is that week blocked off for anyone for any reason? So
Nobody's supposed to be traveling.
right. So our next meeting will be the week of January 4th. I'll come back to you in the interim after
Okay.
having heard from Nora. And I think that's it. And we're
That's
at
pending
16.
approval from the Board of Trustees.
What's that?
And that's pending approval of the extension.
That's right. We're waiting for our extension. So is there a motion to adjourn?
Motion.
Everyone wants to keep meeting.
yeah,
Vote
let's
to
go.
adjourn.
I second.
Okay, any discussion? If not, all in favor, say aye or raise hands.
Aye.
I wish you all the happiest and healthiest of holidays and New Year. It has been really a great pleasure working with you for the last few months, and I look forward and hope fervently that we will meet again in January, and I wish you all the best.
Thank you very much, Dan.
Thank you, you too.
You too, guys.
All right.
Take
All right,
care.
bye.
Bye-bye.
Have a good week.